Then the cluster have this matter.
My lord, earlier bail of 4 date application rejected by this one.
Go to memo. One memo, please.
My lord.
One memo, please.
Yes, TRPCL last week also mentioned.
GRS matter, my lord, 2018.
Which matter?
GRS matter.
TRP.
GRS matter.
GRS matter. Then
But it was also
limited matters are coming. I will say adjust kariyo.
Lordship, we are submitting the written note of submission in WPC 147/28 of 2013.
147. What is that matter?
Sir, complete.
What is that matter?
Lordship, Hon'Ble matter, arguments are complete. Honorable Court directed to submit the written notes of submission.
but it was one bill 1148/7 of 2023 million. In this case, million, some of the co-accused person already released on bail, the petition custody million more than 5 years.
Sure.
Of legislation.
My lord, TRP CRL number 30 of 2024 may be listed day after tomorrow.
Why?
The urgency is that the petitioner is summons and his appearance is sought on 15th of this month.
So it's not a criminal case. It's not a criminal. What is the exceptional urgency that you have deemed it proper to make a mention? What is the exceptional urgency? Please tell me. No, that memo I will not accept. Yes.
Disengagement of GRS man. One BLAPL 13855 specifically adjourned to 24/1.
Yeah. Specific adjournment जोड़ा रही थी weekly list है सर. Yes.
Supplementary list item number 1 for delivery product.
Delivery photo order का आइए टका सीता नहीं बाबा सीता नहीं नहीं क्या सुबह दी नहीं क्या सुबह order दिया तुम हमने order दिया फाइल टा तो क्वाला टेबल पर थोड़ी था हमने कर भाई दियो टका
Item number 2 for judgment.
Thus, from a conspectus of the analysis of facts and discussion made herein before, this court finds no reason to interfere with the order dated 25/10/2011 and 24/2012 passed by the Director Secretary Education. In such view, the matter WPC numbers 30550 of 2011 and 9619 of 2012 are hereby dismissed. WPC number 31489 of 2011 is allowed to the extent of directing the managing committee of the school to implement the order dated 2011/2011 of the director in letter and spirit without any further delay. In view of the order passed in the aforesaid petitions, no order needs to be passed in WPC number 13949 of 2014, which is disposed of as such.
Item number 3 for judgment.
Last item discussed that data director released on 25 judgment. Last item 7918. Delete upon last time order delete करता है 22 रे. सीधा कहीं चलिए ऐसे आएंगे. Without here not here that should fix it on 25. Hearing का fix judgment सेटा अलगा मैटर ये जजमेंट है इसने नहीं सीधा
सीधे नहीं.
तो डिलीट हो तो दोस्तों डिलीट चीज तो लिस्ट है ये तो डिलीट कर दो तो डब्ल्यूपीसी को डिलीट कर दो आई डोंट हैव टू पास इन ऑर्डर डिलीट कर दो
7918.
25 तारीख
Item number 3 for judgment.
In this case I have held that the anticipatory bail application is maintainable, and in all these 3 cases I have granted anticipatory bail.
Right.
In the result, all the 3 anticipatory bail applications are disposed of in terms of the directions issued here and before. I have summarized my conclusions in paragraph 16 from a conspectus of the, I think Mr. Panda, this matter. May kindly note this judgment that whether being in custody, whether when he is in custody in connection with
Whether he can move.
So my conclusions are like this. From a conspectus of the analysis made herein before, thus this court holds as follows. 1. There is no statutory bar for an accused in custody in connection with a case to play for grant of anticipatory bail in another case registered against him. Anticipatory bail, if granted, shall however be effective only if he is arrested in connection with the subsequent case consequent upon his release from the custody in the previous case. The investigating agency, if it feels necessary for the purpose of interrogation investigation, can seek remand of the accused whilst he is in custody in connection with the previous case and in which no order granting anticipatory bail has yet been passed. If such order granting remand is passed, it would no longer be open to the accused to seek anticipatory bail but he can seek regular bail. So, since in all these cases, no order of remand has been passed or bail has been cancelled,
For your lordship,
I've said, try to,
very reasoned order.
that I will not say. That will be blowing my own trumpet.
It's my opinion, it's not yours.
Item number 4 for judgment.
Thus, taking an overall view of the matter, this court is of the considered view that there is no justified reason to transfer the proceeding from Berhampur to Bhadrak as paid for by the petitioner. The opposite party shall pay the actual travel expenses of the petitioner and her daughter, including a male attendant who may accompany her from Bhadrak to Berhampur, including their lodging expenses. It shall also be open to the petitioner to appear before the court at Berhampur through virtual mode by obtaining necessary permission for the same. If such application is moved by the petitioner, the same shall be considered in accordance with law by the learned judge, family court at Berhampur. In the result, the transfer application is disposed of in terms of the observations made above. Further, unless absolutely necessary, learned judge, family court, Berhampur shall not insist upon the physical presence of the petitioner.
Item number 5 for judgment.
When otherwise on merits, this court finds no compelling necessity of directing transfer of the case from Kujonga to Nayagarh. More so as the petitioner can always seek permission of the court to attend the proceeding through virtual mode by submitting appropriate application. It is needless to mention that if such application is filed by the petitioner, the same shall be considered by the concerned court in accordance with law. In the result, the transfer application is dismissed.
Item number 1 for delivery of order.
This court is therefore not inclined to allow the prayer for amendment. The IA is therefore dismissed. List this matter on. It's method all. Yes.
Pardon to mention item 29. A personal difficulty, step towards instruction. I pray next week not today, only this
Item 29.
29. Instruction was shortfall from the state. Right.
As per for by Sri Mahathir, list this matter next week.
Oh, bless you.
Item 16. Placed before any other bench that Mr. Mishra is appearing. Item 16.
Item 16. List this matter before any other bench as I am concerned.
My lord, I play for item number 14.
No, you cannot go mentioning like this. You were there at the time of mentioning. Why didn't you mention? Now suddenly you no, this is not done. Yes.
Item number 6 to be mentioned.
Mr. Panda, I have brought this for to be mentioned because judgment is almost ready. But all these cases are different.
Yes.
That is the problem. I cannot pass a common order. I will have to pass individual orders.
Separate order.
Separate orders. Though I heard it together while passing judgment, I ran into rough weather. Serious rough weather. Because as I remember this 1513, the first matter,
My lord.
that is a pure and simple anticipatory bail.
Yes.
Earlier granted.
Yes.
I filed bunch of
The other one, my lord, your lordship had granted protection, directed surrender.
So this is done. This can be taken care of. In the other, that Rikanjali, there is a direction for surrender and bail.
Yes.
So once he has surrendered means he has gone to the custody. It's no longer an anticipatory bail. So the order will be different. I think Pradeep Ram, whatever. I should not say enough. Saurabh Chandramaji is the same. Surrender and bail.
I have never seen.
Yes. Then Tapas Ranjan Naik, the other case, that is a pure and simple custody bail. He was on custody bail. Now, after the protest petition was filed, cognizance was taken under 307 and NBW was issued. Or summons was issued, whatever. So it will be a custody bill. It will not be.
Definitely.
The other that Manoj can be also is a bit different because their anticipatory bill was granted by a coordinate bench on the condition that it will be subject to the condition that no graver offences are reported. But then what happened is on the very next day, charge sheet was submitted, the cognizance was taken, and NBW was issued.
Of a graver offense.
On the graver offence. Probably the court below had no knowledge about the passing of this or on the previous day.
Right.
So again, it cannot be compared with the first case. So I'll have to pass separate orders. That is why I brought it under to be mentioned. All these cases have been listed under the heading to be mentioned as they were heard together. But while preparing judgment, it was found that the facts are different in each case, for which it would not be possible to pass a common judgment. So, heard further arguments? Stop. Posted for judgment. In each of the cases, this order will deliver judgment within a week. Almost ready. I tried my best, but I saw that it was just not possible. The study and exhibit will be difficult, and it will create further confusion.
Right.
Yes.
Item number 7, fresh admission.
May I plead? And the petitioner is the wife of the opposite party. The opposite party filed the CP under section 13(1)(e), dissolution of the marriage in the court of the
Wanted from Puri to Bhubaneswar.
Puri to Bhubaneswar, my lord. They residing at the petitioner is residing at the Bhubaneswar, my lord. The life risks, my lord, so no financial condition is
What
very.
life risk? Have you filed any FIR? Have you lodged any FIR? Life risk
ସେ ତାର ଛୋଟ ପିଲା ଗୋଟେ ଝିଅ ଅଛି ତେଣୁ ସିଏ ତାର
ବେଶୀ ହେଲେ FIR ତ ଫାଇଲ କରିବା କଥା ଏଇ କେସରେ ଯଦି ଆପଣଙ୍କ ଝିଅଟେ ଅଛି ଆପଣଙ୍କ ଛୋଟ ଛୁଆଟେ ପୁଣି
ଲାଇଫ ରିସ୍କ
କଣ ପାଇଁ କି is there any chance of settlement?
ସେଟେଲ
What section 13 petition?
chance of
Section 13.
section 13(1)(e).
No, you are the wife, you say
Yes, my lord.
whether there is any chance of settlement.
ମୁଁ ରହୁଛି ଭୁବନେଶ୍ୱରରେ ତେଣୁ ପୁରୀକି ଯିବା ପାଇଁ କଷ୍ଟକର
You Bhubaneswar କଣ ଗୋଟେ ବହୁତ ବଡ ଜାଗା?
ମୋର ନା ମୁଁ ସେଥିପାଇଁ ମୋର ପ୍ରୋବ୍ଲେମ ଅଛି
Where have you said that in your transfer application? Let us see.
ମୁଁ 6 para 6 ମେନସନ କରିଛି my lord.
That the petitioner is a very poor lady and is residing. Well, I take notice. You should notice the opposite party by speed post. Requisites for which shall be filed by day after tomorrow. Place this matter on 30th April. Further proceedings in CP number 82 of 2022 pending in the Court of Learned Judge Family Court Puri shall remain state in the next date.
Item number 8.
May I plead? The order under Annex 3, the challenge where the opposite party member has been selected as Jogana Sahayaka.
That's a letter.
Annex 1,
Analyst approval. You are the
advertisement, my lord.
Yes.
Last date of submission of application is 22/8/2022.
No, Annex 3 is what you are challenging.
Yes,
That has been issued in respect of opposite party number.
opposite party number 7.
Opposite party number 7. How are you agreed?
My lord. As per advertisement, my lord, page 10, last date of application,
Sir, where is the advertisement?
my
Where is the advertisement?
Annex 1, page 9.
Yes.
At page 10, it is mentioned
आवेदन पत्र दाखल शेष तारीख
22/2022.
So
And the experience he has received, Annex 4, my lord, on 1/8/2023.
what is this annexure? 4.
Annex 4, my lord. This experience must be issued by district panchayat officer. It is mentioned in advertisement, my lord. अभिज्ञता हासिल करिथिबा प्रार्थी प्रार्थिनी को page 10, my lord. Page 10. अभिज्ञता
प्रार्थी प्रार्थी को अग्राधिकार दिया अभिज्ञता प्रमाण पत्र जिला पंचायत अधिकारी के द्वारा अनुमोदित होइतिबा दरकार.
my lord. It is issued by DPO on 1/8/2023, but last date of submission was 22/8/2022. After 11 months, he has received that experience certificate. And I have been placed in serial number 1 in the selection list, my lord. Annexure 2, page 11. And the opposite party number 7.
His experience relates to 13/5/2022 to
But that was received on 2023, July 2023.
No, all others have signed on 2022. In 2020,
But that must be issued by DPO, Kolahandi, DPO, my lord.
Yes.
And he had signed that document on 1/7/2023.
Yes. So what is wrong in it? What is wrong?
As an experience certificate 2023, after 11 months he obtained that certificate.
Yes.
But last date of submission of the application form was 22/2022.
ଅଗ୍ରାଧିକାର ଦିଆଯିବ ସେଇ ବେସିସରେ ସେ ସିଲେକ୍ସନ ହେଇଛନ୍ତି ବୋଲି କୋଉଠି ଲେଖା ହେଇଛି? ତାଙ୍କ ଅଗ୍ରାଧିକାର ବେସିସରେ ଦିଆଯାଇଛି ବୋଲି କଣ କୋଉଠି ହେଇଛି? Let us see the selection proceeding.
My lord, I have been placed on serial number 1.
Yes.
Page 11, my lord,
You are
annexure
Sachin Sahu.
2. Sachin Sahu.
Manmohan Kumar Bhagat.
And the opposite party number 7 placed serial number 7, my lord.
Yes, take notice.
He has represented before the collector that my royal friend has also annexed. Let him apply his mind and
Sorry.
annexure 5 at page 14.
Annexure 5 has been forwarded to the video.
Under annexure 6, my lord.
Yes, yes. So let him look at it. Huh? The petitioner approved this court.
Collector find out.
But he has already given it to the video. Let the video inquire and submit a report to the collector. So collector will take a final decision. That I will say.
So that would be better, yes.
The petitioner has approached this court seeking the following relief. The case of the petitioner is that pursuant to advertisement dated 25/7/2022 for engagement of Jogan Sahayaks, he was an applicant. In the selection process that followed, he was placed at serial number 1, having secured 66.59% marks. The opposite party number 7 was placed at serial number 7, securing 48.85% marks. However, by a letter dated 31/3/2023 of the Sarpanch of the concerned Gram Panchayat, opposite party number 7 was issued letter of engagement, purportedly being the first candidate as per his experience in job. It is submitted by learned counsel for the petitioner that the experience certificate obtained by the petitioner is after the last date of submission of the application as per the advertisement, that is 22/8/2022. Therefore, according to him, the opposite party number 7 was not eligible. More so, having been placed much below the others, including the petitioner, in the final select list. Highlighting his grievance as above, the petitioner approached the collector, Kolahandi, by submitting a representation. Said representation appears to have been forwarded to the BDO of Bhavanipatna by the collector
With
direction to look into the matter personally and to take immediate needful action under intimation to the applicant, bracket to petitioner. Stop. It is submitted that no action has been taken on the representation as yet. This court, since the grievance of the petitioner is pending before the appropriate authority, it would not be proper for this court to interfere at this stage. The writ application is therefore disposed of with a direction to the BDO of Bhavanipatna. BDO is a party.
Yes.
The BDO of Bhavanipatna, bracket opposite party number 5, to submit the necessary report to the collector, Kolahandi, within 2 weeks, whereupon the collector shall apply his mind to to the report so submitted vis-a-vis the representation of the petitioner and dispose of the same by passing a reasoned order under intimation to the petitioner within a further period of 4 weeks.
If not already, because it was sometime in July
It
2020.
is needless to mention that if the representation of the petitioner has already been disposed of, this order shall be inoperative.
Item number 9.
The petitioner is presently working at Sikasa Head pursuant to engagement order since 2004, 14 to 2004. Now continuing in the meantime 19 years of service. Now letter of so called notice has been issued for why your service will not be terminated unless a 4 my lord. And it's page 17. The Lordship page 17 with reference to the subject cited above and to inform that you have filed a case before such and such which was disposed of 6/2/2003. You have been continuing in service of Sikasa cases with reference to the interim order passed under OAT number 41/2022 in OA number such. Now the case is disposed of with your case. Hence your engagement has been affected by the order 29/4/2004. 11/2003 Hon'Ble High Court Orissa may Appeals Court of India. Hence you are requested to submit so cause file he will not be taken. Accordingly, I have filed also so cause.
What is this WPC number 11748 of 2008?
Hursikasa Bandhani. Taking into consideration the case, this order has been issued. Taking into consideration the case in the case as Hursikasa Bandhani. In the case of 2003, 2 phases post were sanctioned. So far as first phase post is concerned, selection was made in due process of selection as per the advertisement. So far as second phase is concerned, selection was made as per the circular instructed by the OP number 1 without any advertisement. Therefore, this court held that the appointment who were appointed against the second phase sanction post, their appointment is null and void. Accordingly, pass the said letter. Because my appointment was within the sanction post as per the advertisement, and he was placed under the list prior to the letter dated 26/9/2023.
Yes, what do you say, Mr. Das?
I'll have to take inspection.
You have to file a counter in this case.
Similar cases also order. Similar cases order has been passed and Sir 6 also. I have given also one and Sir. Entry orders with notice similar cases. And Sir 6.
You can appear for all.
Yes.
Yes.
You can also appear for project director OSEPA.
Yes.
All school
All right.
masters.
Learned AGA waives notice on behalf of all opposite parties. Let 7 copies of the writ application be served upon him within 3 working days. Is this matter may record 8th May 2024. Till such time, no coercive action shall be taken against the petitioner.
Yes.
Item number 10.
May I please your lordship? My lord, petitioners before your lordship are Group C employee.
Just a moment.
Last order, your lordship's last order.
I'm reading that.
20th March. State Council was requested to clarify this.
Yes.
Counter affidavit has been filed.
No, nowhere it has been said in that Industries Department letter that it is a one-time settlement. You also took that same plea in your counter. That is why you were asked to explain this apparent incongruity. Nowhere it has been mentioned that it is a one-time settlement. You have somehow created that. That is why I asked you to explain.
Let me take further instruction.
What further, Mr. Das? Courier 3 list itala.
Okay.
Already 20 days, more than 20 days have passed.
Monday, let it be on 15th. Let me see.
Our orders are not being complied with.
No, it is being complied with. But what has happened in this case, let me know.
Now, is there any communication to the authorities?
Yes.
So they have not responded.
No, they promised to respond but have not responded.
How can they ignore the order of the High Court?
They cannot ignore.
She said date purpose dodi kasi koriki deiti bagatha. They must instruct you. Why are they not? Why are they so callous? I don't understand. I'm saying in one case I am going to pass an exemplary punishment. I will not hesitate to pass that, sir.
Many of
Because
the.
what happens is the court is being parallel. This is a 2010 matter. And now I remember that Sarango thing.
Obliged, madam.
Sarango. Indira Gandhi Institute of Technology, Sarango.
IIT
There was a merger of
Mushi
states.
Burla.
Yes, merger of states.
Okay.
And only ground was that it was a, insofar as Burla is concerned, it was a one-time settlement, but it is not mentioned in the.
This is a ground of rejection, nothing else.
Learned AG submits that he has not received the instructions solicited by him from the opposite parties and requests for a short adjournment. This being a case of the year 2010, this court expects that the matter should be dealt with by all concerned with due promptitude. As a matter of, as a last chance, one last opportunity is granted to the state to explain the incongruity mentioned in order, as reflected in order dated 23/2024. List this matter next week. It will come next week. List this matter on,
18th April, the next week.
18th April. 18th April, Mr. Mahathi.
Obliged.
Item number 11.
Obliged.
Yes, Mr. Vera.
On the last occasion, your lordship already had that matter. I have already judgment in place the judgment. The Suvarnarekha irrigation project completed high school.
Yes. Sir Mohanto. Jawahar Mohanto or somebody.
Jawaharlal Mahanta.
Jawahar Mohanto, yes.
They have given me the scale of pay from 2005. Subsequently, in the counter, they have modified to 2002. But my prayer is from the initial date of appointment 29/7/95. Since the post was created in 94. So, your lordship directed to think about it. So, I file an amendment petition to modify that Annex D and D.
File.
Again. No, file was list 5082 of 24.
5082.
Flat C. ସେଥିରେ ଖାଲି that
You want to modify your prayer?
to accept that.
What do you have to say in this regard? Would you like to file any objection or you have any objection to the?
Perhaps copy of the amendment petition has not been sought. There is a formal amendment.
IA 5082 of 2024. By means of this application, the petitioner wants to incorporate two further documents to the writ application and to amend his prayer as per the schedule. It is submitted that the documents in question have a material bearing on the facts of the case, and therefore are required to be considered at the time of final disposal. Required to be considered for a just decision in the case. Stop. It is further submitted that the amendment is formal in nature. Stop. Did I record your objection?
No.
Learned State Council has no serious objection to the prayer for amendment being allowed. In such way, the matter, the IA is allowed. The petitioner is permitted to amend his writ application as per the schedule to the IA. Consolidated writ application be filed. Are you not ready with the consolidated? By filed within a week. List this matter on 24th April.
Consolidated copy may be sought out.
Consolidated?
File for short.
Consolidated after serving copy on the State Council.
Item number 12.
24%. Month old.
Direction was government regulator letter.
Yes, sir.
Why don't you file it by way of a memo, Mr. Ratha? Just let us see first.
Yes, sir. The flag mark 1 meter.
In inviting a reference to him, I'm direct to say that there is no new ground on which the matter can be submitted for reconsideration. Last time, if I remember correctly, there was a sort of a contradiction available. Firstly, university.
Contradiction is the counter filed by the government.
No, because they said
Yeah.
university can take its own decision.
Yes, ma'am. On the one hand, they have said.
In spite of that, now they're saying that the university is saying that the government has regulated the proposal.
Because in 2000, I had showed your lordship on last packet, and I will also show. In 2000, government directed all the universities to abolish all the base level posts. Therefore, the abolition the posts were abolished. When the petitioner filed the case, he was at
Abolition of the base level vacancies, not persons who were already in place.
Interview was,
No, there was no interview. There was only panel list was prepared. A panelist was prepared. He was at serial number 3 million. 1, 2, admittedly, in 2009, three persons were engaged on contractual basis. Since 2 posts are available, the serial number 1 and 2 have been regularized on contractual basis after completion of 6 years. So far as this petition is concerned, unless a post is available, it could not be regularized by the university. Therefore, the university sent a proposal either to revalidate the abolished post. So in reply, this is the letter of the
It relates to another letter because this says there is no new ground on which matter can be submitted.
Previously,
So previously there must have been some communication.
no, there no communication was received after the.
Yes, well, if you look at in inviting a reference to letter number 64710 dated 39/2009, have you enclosed that letter?
Yes, that's last letter, 39 last letter. I also understand the counter, you are supposed to see the last one, page 9. Previous one.
Yes, previous letter.
Yes. The creation of post.
I am request you to consider the matter once again.
Yes, Miller.
So earlier you must have again you must have communicated to the government.
Yes, that letter is not with me, but I in instruction we have said, Miller.
There are three letters actually, 2/2009, 19/5/2009 and 25/7/2009. According to the orders of the Hon'Ble High Court of Orissa, by order number 8, arising out of this case number passed order of this case to be read. So government once regulated it.
finance department regulated.
No, initially what they did is because of the order passed in the writ application filed by the petitioner earlier. So they wrote to the government that creation of post of artist is essential at present for posting of Sri Lakshmikanta Patnaik, the petitioner, to avoid contempt of court. But the finance department regretted it. For whatever reason, I would like to see that letter.
The reason has been given why it regretted.
Where is that letter itself? Reason may have been given, but unless the letter is itself is produced, you must be having a copy of that letter. You have referred to that letter. Letter number 18670 dated 25/7/2009. So letter there, Pratham is saying there. There they may have said why they are regretting it. Because now in the second letter, they are simply saying that no new ground has been given. That is why they are regretting it again.
No, perhaps this is the ground, paragraph 8 of the counter affidavit which was filed by.
No, that's all right. I will accept it, but again, I will paragraph.
Para 9 also.
Counter filed by opposite party number 213. No. Counter by
opposite party number
1.
1.
Para 9, they have clearly said that matter is matter relating to creation, abolition of post and appointment made under OUAT establishment is within the purview of the university as it is an autonomous body. Para 9. They have also power. They appointed me. And he continuously served from the year 2009. Now they are saying that post is not available. After my appointment, post was abolished in the year 2000.
Yeah, so this by itself, Mr. Das, this contradicts the government stand. Government could have also said it in the letter instead of regretting it.
No,
is it not a prevaricating stand? Here the government says
paragraph 8, it has been said, in this context, it may be stated that as per page 12 of the Indian Council of Agricultural Research, ICAR manual, the artist post is available in the ICAR institute, but not in an agricultural college.
That is besides the point. Already 2 persons have been appointed. Yes. You have not raised any objections. That is totally besides the point. But in paragraph 9, whatever you have said completely contradicts your regret letter, because the same thing could have been said in your regret letter, that you are competent, you may publish the post. It is just not a question of granting it. So this is creating a mess. So what I will do is I will ask Mr. Rathod to produce that letter also.
Yes, that's my director.
As directed, Sri S.C. Rathod, Learned Counsel appearing for the OUAT, has produced letter dated 17/12/2009 of the government in agriculture department, government in the erstwhile agriculture department, whereby the fact of regretting of the proposal, fact of regret of the proposal by the finance department has been mentioned. Copy of letter dated 30/9/2009 which was of the university, which was replied to by the agriculture department, has also been produced. It is found that earlier the government, on the request of the university, had also regretted the proposal in its letter number 18670 dated 25/7/2009. This court would like to peruse the said letter, including the letters of the university pursuant to which such letter was issued. Sri Rathod, Learned Counsel appearing for the OUAT, is requested to furnish copies of all such relevant communication between the university and the government for perusal of the court. List this matter on 24th April. Yeah.
Okay. 15 years he has solved.
It's all that I will consider. Paragraph 9 is and I would welcome Sri Das, Learned AGA, is requested to explain the apparent contradiction in the stand of the government as reflected in paragraph 9 of the counter affidavit vis-a-vis the regret letter issued to the university. Here you say that they can create their own post. There you say that the proposal is regretted. All right.
67 age ହେଲାଣି।
Item 13.
ଆମେ ତ ଆଜ୍ଞା ଆମେ ତ ଏଠି ପେଣ୍ଡିଂ ରଖିଲୁଣି 2011 ମସିହା 2011 ମସିହା ହେଲା ମାନେ 13 ବର୍ଷ ଆମେ ପେଣ୍ଡିଂ ରଖିଲୁ ନା ଆମେ କାହାକୁ ଦୋଷ ଦବୁ? It's our mistake also. Yes.
Item number 13, my lord. As I was directed to submit further affidavit, my lord, in this case.
Yes.
My lord, it was filed to e-filing, my lord, on 8/4/2020. I'm serving a hard copy also.
No.
And today I'm also serving a copy of the same, my lord.
As directed, Learned AGA files an additional counter affidavit in court. Have you served copies? After serving copy on the counsel for the petitioner. Same be kept on record. Yes. Let's this matter on 18th April.
May I be permitted to submit only one thing, man?
As learned counsel for the petitioner wants to go through the additional counter and make his submissions accordingly. Yes.
Our specific stand, my lord, with the self-same prayer, the petitioner moved before this honorable court, my lord, in OJC number 515 of 2000, which was dismissed on 6/2/2006. So, may I pray, my lord, this matter may be also, I'll do this one. For reference.
Release this matter on 24th April along with OJC number 8816
515 of 2000, my lord. Three numbers of petitions were filed, my lord, previously.
OJC number 515 of 2000.
2000, yes.
Item number 14.
Silent. Gentlemen, I pay only 7 days time.
Last time also we wanted time.
Last time.
Mr. Chand, the learned counsel for the petitioner requests for a short adjournment. So, release this matter
22nd.
on 22nd, 24th April.
Again.
Stop. It is made clear that no further adjournment shall be granted.
Item number 15.
Short adjournment.
Yes.
Short adjournment. But they filed a public paper.
You want an adjournment? 2024 matter already.
I see the government is our.
As requested by learned counsel for the petitioner, as requested by learned counsel for the petitioner. Release this matter.
Issue the death set.
Release this matter on. कौन भूली जी इनती किन देखो जी भूल matter नहीं है wrong matter has been
It is 6874 of 2012.
2024 तक से नहीं है CPM को जी 2024
It was listed yesterday.
कल था नहीं non appears for the petitioner ही था non appears ही था for the petitioner
I am for the opinion.
कल ही था so what do you want
पढ़ोसी कुछ जानना थी तो कल ही रहो पौधे रहो कुछ जानना थी
as requested by Sri Mahathir learned counsel of the petitioner, let this matter on 12th April. पूरा 2012 matter कहीं रखे
तो पॉज 12 obligation.
Item number 17.
16.
The petitioner was initially appointed on 18/6/82 on 9/10/87. Then he was promoted to the post of Deputy General Manager on 18/6.
So counter is not there. No counter is not necessary.
Sir, the minutes, sir.
Yes.
And after promoted to the post of Deputy General Manager, he resigned from the post on 15th of October 2000, 5th of December 2010. His resignation was accepted. Some area dues are there. He has applied for the area dues since they have not given it. That's why the petition is filed. Well, they have not filed any counter. In the meantime, I do not know because 10 years have passed. 12 বছর হয়ে গেল, 12 years have passed. Let me get enter if I have got the relief, then I may not press it. If you will not get it, then I will.
I am appearing, my lord. I am appearing on VCL also may permit me. I am appearing for the opposite party. My senior has challenged the order under annexure 7 is a show cause notice claiming 12,720 for recovery. That is a show cause, also may see. And whether reply has been given or not, that is also not on record. And so far the order.
No, but if the petitioner has got the relief in the meantime, I'll adjourn it to only 1 week.
Yes, yes.
After, so that you can take it.
I may not press it.
As requested by Sri J.K. Rothalan, Senior Counsel, raise this matter on 18th April. Oh, 18th April.
Yeah.
18th April.
22nd রকম স্যার।
Till 25th April. No, 24th April. 24th.
Item number 18.
May I please? Last occasion, the state was directed to get the copy of the order passed by the Human Rights Commission. Here the matter is that the petitioner was working as a Asha Karmi.
I'd like to page the order of the Human Rights Commission.
My lord, I have the entire documents, but today, my lord, in the morning hour, while I was going through, my lord, I just found that, my lord, the annexures have been not properly arranged. Annexure 1 ta tole rahi jaise.
I will check it up then day after tomorrow.
Day after tomorrow.
Yes.
Because I have the copy.
Sri S.N. Patnaik, learned AGA, submits that he has received the required documents.
Sir,
For the same, I would like to present the same, for which he requires some time. Please this matter day after tomorrow.
Item number 19.
Consolidated petition filed. Okay, time.
You filed it.
Yes, yes, filed it, solved the copy yesterday.
Consolidated writ application has been filed within time stipulated by this court. The writ application is therefore taken up for hearing. Yes, place it.
Please absent when the current set of
Consolidated it requires an additional affidavit.
Yeah, amendment was allowed.
Amendment was allowed, but there are a lot of new facts related to very old time. So I pray some time now knows that most of the staffs taken away for relation duty and all these things, but still I require the register to immediately send me the information to file the additional. Because
Council appearing for the university requests for some time to obtain necessary instructions with regard to the amendments made in the consolidated writ application.
I will file counter, additional counter is required by
which he has received yesterday. So he further submits that an additional counter affidavit would be filed by him, for which he requires some time. Is this matter on 30th April? Additional counter if any be filed in the meantime. Since this is a case of the year 2013, the parties are requested to come ready for final disposal.
Item 20.
On the last occasion, there was a direction to file the counter. But on 8/4/2024, I received a far-wise comment wherein we have the instruction along with the document evidences. The candidature of the petition has been rejected and it has been reflected in the reject list. We will produce it, my lord, through counter affidavit.
No, your last chance was granted, Mr. Patnaik. You should have been ready with the counter.
Yes, but
why didn't you file the counter affidavit? I have passed an adverse order on the last occasion. If you file it in course of the day, I'll take it up day after tomorrow.
It is the affidavit is to be shown by.
So we'll come and show the affidavit.
No, from Malkangiri.
So what Malkangiri? Plain ratio, use? Jaipur ratio, plain ratio. Every day the 2 flights are operating now. ସେ ପୁରୁଣା ମାଲକାନଗିରି ଖାଲି କହିଦେଲେ 600 କିଲୋମିଟର ବୋଲି କଣ ଆମେ
ମୁଁ 12 ତାରିଖ ଦିନ ଦେଇଦେବି ଡେ ଆଫ୍ଟର ଟୁମରୋ।
CAG Patnak Leonard AG submits that he is ready with the paravoice comments, but has not been able to file the affidavit as the concerned officer has not as the concerned officer is to come from Malkangiri. Release this matter on 18th April. Counter affidavit be filed positively in the meantime after serving copy on the counsel for the petitioner.
Item 21.
May I please, yours? Petition in the city application, my lord, sir. Challenges the my lord study. Challenges the annexure 4, 8, and 7, my lords.
Yes.
The case of the petition is my lord, will have
Notice has been issued.
A notice has been issued. They have filed a counter.
All right.
The
What are the facts?
Case of the petition is my lord. The advertisement was made for the post of Hon'Ble worker. Kindly last to annexure 1, my lord, page 1, page 11 of the moment.
Yes.
That is 10. That is a big jump. No, the third line. 10 ଗୋଟି ନୂତନ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ଅଙ୍ଗନବାଡି କର୍ମୀ ନିମନ୍ତେ ଅନଲାଇନ ମାଧ୍ୟମରେ ବିଜ୍ଞପ୍ତି ଜାରି କରାଗଲା। ଥାର୍ଡ ଲାଇନ ଫ୍ରମ ଦ ଟପ୍ ମେରିଟ୍ସ।
ବିଜ୍ଞପ୍ତି ଗୋଟି ନୂତନ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ଅଙ୍ଗନବାଡି କଣ ଗଲା?
ହଁ ଅନଲାଇନ ମଧ୍ୟ କ୍ଲଜ 1 ମାଇନର୍ସ। ଦେयर ଆର୍ ଟୁ କ୍ଲଜେସ୍। ଆଇ ଏମ୍ ରିଡିଂ ଦ ଟୁ କ୍ଲଜେସ୍। 1 ଉକ୍ତ ପଦବୀ କେବଳ ମହିଳାମାନଙ୍କ ପାଇଁ ଉଦ୍ଦିଷ୍ଟ ପ୍ରାର୍ଥିନୀ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ନିମନ୍ତେ ଦରଖାସ୍ତ କରିବେ। ସେହି ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଅଞ୍ଚଳ ସାହି ପରିସରଭୁକ୍ତ ବାସିନ୍ଦା ହେଇଥିବେ। ଯଦି ସେହି କେନ୍ଦ୍ର ଅଞ୍ଚଳ ସାହି ପରିସରଭୁକ୍ତ ନ ମିଳନ୍ତି ତେବେ ତାହେଲେ ଉକ୍ତ ଗ୍ରାମାଞ୍ଚଳରୁ ଆବେଦନ କରିପାରିବେ। ଯଦି ଉକ୍ତ ଗ୍ରାମାଞ୍ଚଳରୁ ନ ମିଳନ୍ତି ତାହେଲେ ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଞ୍ଚଳରୁ ପ୍ରାର୍ଥିନୀ ମାନେ ଆବେଦନ କରିପାରିବେ। କ୍ଲଜ 8 ମାଲର୍ସ। ସୋରଡ଼ା ବ୍ଲକ ଗୋଛା ଓ ଗାଜଲବାଡି ବ୍ୟତୀତ ଅନ୍ୟ ସବୁ ପଞ୍ଚାୟତ ଅନୁସୂଚିତ ଅଞ୍ଚଳ ସେଡ୍ୟୁଲ ଏରିଆର ଅଧୀନସ୍ଥ ଅଟେ। ତେଣୁ ନିୟମ ଅନୁଯାୟୀ ଅନୁସୂଚିତ କେନ୍ଦ୍ର ପାଇଁ କେବଳ ଆଦିବାସୀ ହରିଜନ ପ୍ରାର୍ଥୀମାନଙ୍କୁ ନିଯୁକ୍ତି ଦିଆଯିବ। ଯଦି ଗ୍ରାମାଞ୍ଚଳରୁ ଆଦିବାସୀ ହରିଜନ ପ୍ରାର୍ଥିନୀ ନ ମିଳନ୍ତି ତେବେ ଗ୍ରାମ ପଞ୍ଚାୟତକୁ ୟୁନିଟ୍ ଭାବରେ ନିଆଯାଇ ଯୋଗ୍ୟ ପ୍ରାର୍ଥିନୀ ଚୟନ କରାଯିବ। ଯଦି କେହି ପ୍ରାର୍ଥୀ ପଞ୍ଚାୟତ ମଧ୍ୟରେ ଗ୍ରାମାଞ୍ଚଳ, ଯଦି ଗ୍ରାମାଞ୍ଚଳ ନ ମିଳେ ତେବେ ପଞ୍ଚାୟତ ଅଞ୍ଚଳ। I have applied through online by the annexure 2, my lords. And annexure 2, my lord, I have said that I have in Palakattu, Gram Panchayat Palakattu. Then, my lords, they verify the annexure 3, my lords, they verified the application form. That is annexure 3 at page 15. Just last one, पुनश्च एथे देखागला निम्नलिखित केन्द्र ପାଇଁ आवेदन କରିଥିବା ପ୍ରାର୍ଥିନୀ ଧାର୍ଯ୍ୟ ସମୟରେ ମୂଳ ପ୍ରମାଣ ପତ୍ର ଗୁଡାକ ଯାଞ୍ଚ ନିମନ୍ତେ ଉପସ୍ଥିତ ଏଣୁ ନିମ୍ନଲିଖିତ ଯୋଗ୍ୟତା ଭିତରେ ନାମ ଓ ଠିକଣା ପ୍ରକାଶ କରାଗଲା। And my name was that is next page number page 16 ବିଦ୍ୟାସିନୀ ଗୌଡ଼ ବାଡୁଅପଲ୍ଲୀ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ବାଡୁଅପଲ୍ଲୀ ପାଇଁ। Two persons are there.
Yes.
2 persons are there. And next my lords, annexure 4, they have selection committee. Selection committee without any giving reasons, my lords, they cancelled. My lords, that is last line, my lords. 8 out of 10, my lords, 8 centers names were declared. And last ବାଜିବାର ବାଡୁଆପଲ୍ଲୀ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପାଇଁ ଯୋଗ୍ୟତା ଭିତ୍ତିକ ପ୍ରାର୍ଥିନୀ ନ ଦିଆ ଯୋଗୁଁ ଚୟନ ପ୍ରକ୍ରିୟାରେ ଚୟନ ହୋଇପାରିଲେ ନାହିଁ। ତେଣୁ ଉକ୍ତ କେନ୍ଦ୍ର ପାଇଁ ଚୟନ ପ୍ରକ୍ରିୟା ରଦ୍ଦ କରାଗଲା। That was I have filed an appeal before the appellate authority. And appellate authority, my lords, directed that not to conduct any interview. And subsequently, my lords, while the matter was subsidized, another advertisement was made by the annexure 5. And at that time, the terms of advertisement conditions was changed. Then, my lords, in the appeal, my lords, by the annexure 6, my lords. That is, District Magistrate Ganjam has passed an appeal in favor of me, my lords. That is page 25 of the brief, my lords. Page 25.
Yes.
In view of the above submission made by the appellant, parallel commentary submitted by the CDPO SORA ICDS project, and after going through the guidelines of the government issued from time to time on selection of Anganwadi worker, I am in opinion that selection committee, while taking the decision on the selection of Anganwadi worker for Baruapalli Anganwadi center, has not properly examined the notification and government guidelines. Hence, in view of the points raised by the appellant, highlighting the notification issued by the CDPO by the point number 1 and 8, the notification dated 466 dated 24/6/2001, that the annexure 1 matters. The case is remanded to the selection committee with an instruction to examine the prayer of the appellant with reference to the aforesaid notification along with other candidates and take a fresh view of observing the government guidelines. Then the CDPO Sorora is directed to place the matter before the selection committee forthwith, and decision should be taken by the selection committee within 4 weeks this matter. Till disposal of the matter, the selection committee, the order dated 3/11/2021, which was passed in interim order matters passed by this court, shall be in force. Then the selection committee, without going to the annexure 1 matter, that is again matters, that is selection committee rejected my case, that is at the page 30 of the brief matters, annexure 8. Page 30. The sub paragraph. उक्त बैठक विज्ञापन पत्र संख्या 24/6/2021, that is annexure 1, क्रमिक नंबर 8 बारुआपल्ली ग्राम एक अनुसूचित जाति और जनजाति ग्राम अटे। बारुआपल्ली ग्रामर अंगनवाड़ी केन्द्र निमंते दरखास्त आवेदन कर प्रार्थी श्रीमती विद्यासिनी गौड़ केन्द्रांचल बासिंदा नुहति एवं श्रीमती गायत्री महाराणा बारुआपल्ली ग्रामर स्थायी बासिंदा हेले मध्य ऑनलाइन दरखास्त आवेदन करने समय स्थायी बासिंदा प्रमाण पत्र संलग्न करनथिले। एवं समस्त विषय को आधार करी चयन कमिटीर समस्त सदस्यवृंदर निष्पत्ति क्रमे बारुआपल्ली अंगनवाड़ी केन्द्र अंचल पुनर्बार विज्ञापन जारी करने निष्पत्ति नियागला। Then matters annexure 7 was issued, that is advertisement. That is Anganwadi,
Mr. Panda. The additional, the ADM remanded the matter.
Remanded.
The selection committee passed a resolution.
Yes.
Rightly, wrongly, whatever. It is again appealable. It is again appealable. Why don't you challenge that before the ADM again? Your proposition scored because an advertisement was issued, some interim order has been passed.
Yeah, interim order has been passed.
All right. So why don't you go to the ADM? It is his order. He had remanded it.
Remanded it and again it was rejected.
Again rejected, so then now he will test it. He has already expressed his opinion why he was setting aside the earlier order or why he chose to interfere. That the selection committee has not considered the guideline or the government notification, government guidelines also. The advertisement and the government guidelines, which you have pointed out in annexure 1.
Yes.
Correct?
Yes.
So he remanded it, you take a decision considering this. Now they don't consider it, or they take a decision as per their own interpretation. That is to be again challenged before the ADM.
Because
I will permit you to challenge it.
What's my request?
Just a moment.
Yes.
Just a moment. I'll just briefly hear the state. What is your view? What counter you have filed?
The same thing, but it has been narrated by my own brother. That in fact, 2 applicants were there, and one applicant, she didn't deposit or submitted the.
We are not concerned. We are not concerned. What they did initially, they didn't consider any of the applicants.
Actually, my lord.
Yes.
Without taking my concern.
Obvious.
If your lordship will come to that whole ground taken by the authorities.
2/5/2007.
No, 2/5/2007. 2/5/2007, my lord, later on, my lord, it has been, to some extent, it has been amended in the year 2008. With respect to that area, candidates from that different area. Now, thereafter, my lord, to some extent in 9 and on 4/1/2010. What it has been emphasized by the government in their counter, my lord, relying upon that 4/1/2010. Now, my lord, if I will take your lordship to that 4/1/2010, 4/1/10 has been issued, my lord, in supersession to different or in modification to different guidelines, but not touching to that 2008.
So what does it say?
Yeah, 4/1/2010. I am cited. Set up the 4/1/2009.
Page note 72, sir. Page note 72, which is 4/1/2010, which we have relied upon. And this is in supersession to different guidelines.
What does it say?
Well, it says with respect, the preference in the age is to be given.
Preference in the?
When more number of candidates are there, then age will be one of the determining factor, my lord. That is what it has been introduced later on.
No, sir. 4/1/2010.
4/1/2010, it is a page note 72 of that book, my lord.
72, it says revised guidelines for selection of Anganwadi workers modification.
Modification.
In partial.
Then 3A, my lord.
No.
In PTG areas, the female candidates who have the highest qualification from applicants for each Anganwadi center area.
So this does not touch that stipulation.
That is
if
what.
he is not within that service area, then within the village. If not from village, then the
That is why, my lord, I am submitting.
He is speaking in your favor, Mr. Panda.
That is just for course clarification. Next month, 10/3/2010, my lords. That is the one wrongly that 10/3/2010.
Yes.
Clarification of engagement of Anganwadi workers with reference to the subject noted above and directed to same. Same.
Which is already reflected in the advertisement.
Yes.
Now, if your lordship will come to that page note 54 of that book, the condition stipulated in the advertisement, my lord, that who can be the candidates, that has been decided taking into consideration this 2008. And these 2008 guideline had not been superseded in 2010.
But then it will be deemed to have been superseded.
No, 2008 is something related to something different.
No, it says according to paragraph 1 of the revised guideline, the AWW should be resident of the AWC area if no suitable candidate is available in the AWC area. Then candidate of the village could be considered. It does not say anything about a candidate of the same panchayat being considered. It has not said. But in 2010, in over and above this, they say if eligible candidate from AWC area is not available, from village area may be taken. If from village area not available, then adjacent village.
No, that is in 2008.
No, that's 2010.
2010.
Yes, ma'am.
10/3/2010. This does not contradict the previous guidelines at all.
Yes.
This
Well,
is over and
2008 is same as that of 2010, my lord.
10/3/2010. Little different. 2010 says adds the adjacent village under the same gram panchayat, which the petitioner belongs.
Yes, sir.
No, but all said and done, the question is who's to take a decision? The ADM is to take a decision.
These
Send it back to the ADM.
My lord, these things have not been actually placed before the ADM.
What do you say, Mr. Panda?
Because ADM had directed the selection committee.
So when the selection committee doesn't act as per the direction of the ADM, then it is the ADM who is to consider. Why the High Court? High Court will assume the role of the ADM.
Till that time, the selection.
I will protect you. I will definitely protect you. What is the interim order granted in this case?
The my lord has passed that interim order
amendment wala tha bro.
on 3/8/2022.
Third, Sri D.K. Panda, learned counsel to the petitioner, and Sri S.N. Patnaik, learned AGA. The facts of the case are that pursuant to an advertisement issued by the CDPO Soroda, actually the name is Suroda, but everybody says Soroda. The Suroda. In South Odisha, they write O. That is the problem. CDPO Soroda on 24, 24/6 with it?
24/6/7.
24/6/2021. First one.
Advertisement issued by the CDPO Soroda.
2021, inviting applications for engagement of Anganwadi workers for different Anganwadi centers under different panchayats of the district, the petitioner submitted her application online. Stop. Indeed noted that the petitioner belongs to village Dhobadi under Paroka 2 Gram Panchayat. She submitted her application for Anganwadi center ta kono?
Anganwadi center hoche Baduapalli.
Baduapalli.
Yes. Best
Baduapalli Anganwadi center under the Paroka 2 Gram Panchayat. Stop. A merit list of Anganwadi workers was published on 10/7/2021, wherein the names of the petitioner and one Gayatri Maharana were published against said Anganwadi center. However, in the final select list published by the CDPO Soroda on 1/9/2021, the candidature for selection for Anganwadi, the Baduapalli Anganwadi Center was cancelled on the ground that no candidate belonging to the said service area had applied. Stop. The petitioner filed an appeal against such order, against such selection, against such non-selection, being this appeal case number 2 of 2021 before the ADM Ganjam. Stop. In the meantime, an advertisement, a fresh advertisement was published by the CDPO on 23/9/2021, inviting applications for Baduapalli Anganwadi Center. It is submitted that by an interim order passed on 3/11/2021, the ADM no selection shall not be, no selection shall be held.
Yes.
Passed order that no selection should be held pursuant to such advertisement. Subsequently, after hearing the parties, after hearing the petitioner appellant, the ADM, while order dated 7/4/2022, allowed the appeal on the ground that the selection committee had not properly examined the advertisement and government guidelines. The matter was thus remanded to the selection committee with instruction to examine the prayer of the appellant with reference to the aforesaid notification along with other candidates and to take a fresh view observing the government guidelines. Pursuant to such order, the selection committee in its meeting dated 11/5/2022 considered the matter, but reiterated its earlier decision by holding that the petitioner is not a permanent resident.
Is not belong to the center area.
Permanent resident Baduapalli Gramaro. Parthini Srimati Vidyasini Gowda Kendranchalara Basinda Nuhanti.
Kendranchalara means center area.
Center area is not a resident within the service area of the concerned Anganwadi center, and therefore decided to issue advertisement afresh. Stop. Pursuant to such advertisement, pursuant to such decision, further advertisement has been issued on 19/7/2022. Stop. Being aggrieved, the petitioner has approached this court seeking the following relief. The counter affidavit has been filed by the state opposite parties referring to the advertisement notification dated 24/6/2021 and the relevant guidelines of the government in this regard. In course of hearing, it is submitted by learned State Council that as per the extant guidelines, it is permissible for the selection committee to select a candidate from an adjacent village under the same Gram Panchayat if no candidate from either the service area or village in question is available. Stop. This court, however, is of the view that the matter having been remanded for fresh consideration by the selection committee, the matter having been remanded by the ADM to the selection committee for fresh consideration, for reconsideration. And a decision, rightly or wrongly, having been taken by the selection committee, comma, the petitioner should have challenged the said decision again before the ADM. Instead of doing so, the petitioner has straightaway approached this court. By order dated 3/8/2022, this court has directed that no appointment shall be given pursuant to advertisement dated 19/7/2024. In such view of the matter, the writ application is disposed of, directing the petitioner to prefer appeal before the ADM Ganjam. Na kaun ADM?
ADM Ganjam.
Ganjam. Think Ganjam?
Additional district magistrate Ganjam.
Ganjam within 10 days.
Yes, within 15 days.
Within 15 days from today. Against the order, against the decision taken by the selection committee on 11/5/2022. Stop. It shall also be open to the petitioner to seek appropriate interim order with regard to the advertisement dated 19/7/2022 by filing appropriate application in the appeal. Stop. If such appeal along with the interim application is filed within the period stipulated, comma, the ADM shall do well to consider the same and pass a reasoned order within a further period of 4 weeks.
Also, election as jaitio se pune aur dekha
For a further period of 2 months. Till an interim order is passed by the ADM on the application to be filed by the petitioner, the interim order passed by this court on 3/8/2022 shall continue. Yes.
Item 22.
Yes.
The opposite party. So please peruse the last order dated 3/4/2024.
Who's for the petitioner?
No.
Yes, sir, you are for the petitioner.
22 रे अपन से सुनिए।
Use that mic. Yes.
Next week, my lord.
Last time also you took time, sir. All right. 2023 matter. All.
The conductive law is suffering. So that advisement to take the time.
All right.
No. Another request is not there. Is not there. That's why I'm confusing.
Request is made for adjournment on behalf of the counsel for the petitioner on the ground of his illness. Place this matter next week? Next week? Place this matter on 18th April.
Item 23.
My pleasure. This application has been made by the wife. The husband has deferred an application for divorce.
Who is appearing? You are appearing? Settlement?
My lord, settlement, I have filed section 9 application. That was allowed. Last occasion also I have submitted that.
You are the husband.
My lord?
You are the husband. Section 9, you have filed means you are ready to take back your vote. Isn't it? Very good.
Expired
Yes, Mr. Nanda?
Expired it was filed, it expired order was taken away and I filed. I have filed an application order in Rule 13. There.
Your institution is not an adverse order. Why are you taking?
Without hearing this.
That's all right. That's all right.
Appropriate application has been filed in the
recall of that order.
Recall of that.
Would your client accept mediation? Why don't you explore?
Probably she is apprehending because she is residing in Malkanagiri with all respect. And she was assaulted and with a small child. And when
With any condition, lordship fix, my lord. I am ready, my lord.
No, let me ask. She is the wife. She's at her convenience also has to be seen.
And when she was assaulted, she went and there is a 5-year-old.
Some difference has arose. Otherwise, why will the parties be before this court?
Yes.
Now, this court, the endeavor of this court would always be to have a peaceful reunion. I make it very clear.
I
agree. So you can have a mediation. Where are you residing?
Malkanagiri.
And you?
Barampur.
So you can have it at Malkanagiri. This mediation at the DLSA Malkanagiri.
My lord, I am ready.
Instead of the lady coming all the way from Malkanagiri to Cuttack.
Malkanagiri mediation.
Let this case be transferred there. So that
not transfer is the pura application of Mungari whether a case for transfer has been made out or not. I am asking whether it is possible for you to.
Yes, will taken in with her.
No, I am not forcing the mediation upon you. It is up to you. Because in these matters, it is always better that they are settled amicably.
You also have stayed the operation of this.
That will continue. Till the mediation is over, supposing mediation fails, then we will hear the application. If it is successful, in some cases it has been successful. When I was sitting in the anticipatory bail assignment, many matters have been settled. These matrimonial cases, I sent them for mediation. There were many.
It can be
not many.
Bail matters, it has been said.
Yes, in the anticipatory bail matter.
After told what I have been informed, he is having another, living with another.
See, by mistake. All right. The stay will continue.
Yes.
In course of hearing, it is submitted by learned counsel for the parties that the dispute between them being such that an attempt can be made to resolve the same amicably through mediation. Stop. In such view of the matter, and since the petitioner wife is residing at Malkanagiri, this court directs the records to be placed before the Secretary DLSA Malkanagiri, who shall appoint a mediator from the panel. Stop. The parties are directed to act upon receipt of notice from the mediator and to render full cooperation in the mediation proceeding. Let's this matter, Mayor Kora. Let's this matter on 15th.
Date lumbar ho, kana Malkanagiri report.
15th May. Taapre piche bar kono na?
Mala.
Masa era nahi kono. 15th May.
Masa.
It's in order to continue till then.
Item 24. Refusal lodge.
Since pursuant to lordship's direction, I have already filed the requisites.
That is
not
moved.
I will file 10 days time if given. I file the requisites.
You have the new address?
Yes, ma'am.
All right.
And I have, in the meantime, last occasion, I was not accompanied. Lordship may kindly consider.
Issue fresh notice to the opposite party by speed post. Requisites for which shall be filed by day after tomorrow. Stop. Requisites be filed indicating the present correct address of the opposite party. Voila. List this matter on what is short date? 30th April.
Earlier it was not accompanied today.
IA 92 of 2024. Further proceedings in civil suit number 141 of 2020. Pending in the Court of Learned Civil Judge Senior Division, Sambalpur, shall remain state till the next date.
Obliged.
Item 25.
May I please, your lordship. Under this matter, my lord, relating to the relaxation of age, the matter of selection of Sikha Sahag, my lord. Lordship, my lord, in the batch of matters, your lordship fixed to 30th of this month, my lord.
Relaxation of age?
Relaxation of age or Sikha Sahag, my lord.
Sikha Sahag.
I've heard similar matter.
Your Lordship had and fix of this batch of cases to 30th of this month, my Lord.
30th.
But in this case, counter not filed, my Lord.
In the meantime, you file your counter?
We cannot develop any new stand, my lord, in comparison to what.
If it's not necessary, then no.
Annexure 1 is a detailed order. It has been passed after the lordship remitted the matter to the authorities to consider it.
Okay.
So it is more than a counter matter.
Then it's all right.
In
Satpathy Learned Counsel for the petitioner submits that similar matters have been posted for hearing on 30th
of
April 2024. List this case on 30th April. Yes.
I do not 26.
Counter if you record be
Counter if any be filed in the meantime. They don't file, they'll let them cross. Item 27.
Item 26.
Same batch of matter same.
No, 26 ta gola na?
25.
25, 26 same gola. 27.
Item 27.
In this case, notice was issued, but
No,
though it has been duly served.
Neither AD nor Hon'Ble yet just got tracking
Yes,
report.
appeared on behalf
Notice
of the
was-
husband.
As per postal tracking report, the notice on the opposite party has been served on 28/3/2024. There is however no appearance.
So some new development has in this case, my lord. The husband has preferred another criminal case against the DV against the application under PWDV Act filed by the wife before SDGM Jagatsinghpur. Against that, he has preferred a criminal miscase here. The another bench of this honorable court has passed an order to send the matter to mediation. And now the mediation is going on at Jagatsinghpur.
The problem is if the party doesn't appear here, a mediation order for mediation without the president.
Already mediation has been directed in another case.
No.
That's why I have passed this order.
That's all right. But how the party is not before me, how can I direct?
No, your lordship cannot direct that. But it is going on, but he is now intentionally he is not appearing here. Though the notice has been duly served on him.
What can be done? What can be done? This is not a criminal proceeding.
No.
It's not a criminal proceeding that any coercive order would be, any coercive steps can be taken.
Lordship may transfer the matter to lordship.
Yeah, I will hear, finally hear. So let us wait for some time since mediation is going on.
My lord.
That's why for some time.
That's why I passed this order because that will be suppression of.
It is submitted by legal counsel to the petitioner that pursuant to order passed by a coordinate bench of this court in CRLMC number 237 of 2024. Mediation proceeding is presently in progress, is presently going on before the District Mediation Center, Jagatsinghpur. Stop. The sole opposite party is attending.
It was pleased, but I have not taken any instruction because it was.
In such view of the matter, list this case on 30th April. 30th April.
My lord.
No.
Interim order.
Interim order to confirm.
Item 28.
My lord, yesterday received copy of the counter affidavit filed by my dear.
Who is applying for the opposite party? State. 28, yes, your matter. Is your associate?
Yes, sir.
All right, let him submit. Yes, submit. Yes, submit.
The 2 weeks time to granted to take instruction to file rejoint.
Who has filed counter?
The
State has filed counter. What is this matter?
Sir,
In fact,
yes.
it's a WPC.
WBC. Number कितने?
5205 of 2024.
What is it about?
Sir,
What is it about? This petition. Why has it been filed? What is the prayer? Who are you? Why have you filed this writ application? Yes. Say. कौन पे writ application कौन?
My lord, not going to file.
Yes? Yes, yes. Don't be afraid, tell. କଣ ହେଇଛି ପଢିନାହାନ୍ତି ପଢିନାହାନ୍ତି କୋର୍ଟକୁ ଆସିଛନ୍ତି very bad. You are holding a brief without going through the brief. You are making a submission before the court. No, no. How can you assist your senior then? You have received a copy of the counter. What is this matter? What is this matter, Mr. Das?
In fact,
Selection appointment Jogana sir.
You answer. It's not an appellable order.
No. No, order was passed. That was not complied with and with accounting content.
Then it comes to the petitioner submits that he has received the counter filed by the state. When did you receive the counter? Yesterday. And therefore he wants some time to go through the same. This is next week?
He is to come from Bhavanipat. 8 to 10.
Does this matter? How is he required?
The counter, in fact, advertisement year 2013.
Now who is to come from Bhavanipatna? Your client?
Yes.
Does this matter on 24th? 24th? Interim order to continue.
I don't know, 30. I'm not the OP for 5 million.
Yes?
In that case, I am not the OP.
Doesn't matter. Yes, item 29?
Item 29 already.
Oh, 29. 30? 30 yes.
Compliance affidavit has been filed.
Yes, Mr. Joshi, come your matter.
Yes, yes.
The complaint matter will file a contempt and you are not coming to the court.
That content also yesterday I have submitted copy of the counter affidavit. That also needs some time to file a reply.
So cause complaint affidavit.
Yes, yesterday I have submitted copy.
देखिए कौन लिखा है? Let us see. What was the order?
Order was
to dispose of the representation. Yeah. The selection committee shall take a decision in the matter. Yes. So some decision must have been taken.
Yes.
No. Where is the complaints affidavit, sir?
No, in fact, filed on 6th of.
काय दोन आधी कॉपी दे कॉन्ट्रॅक्ट ऍप्लिकेशन ଅଛି की complaints affidavit. ଦିଅନ୍ତୁ ଇ ଫାଇଲିଂ ହେଇଥିଲା କି
ହାର୍ଡ କପିଟା ବି ଅଛି ଦଉଛି
ଇ ଫାଇଲିଂ ରେ ପହଞ୍ଚିନି କାହିଁକି କିଏ ଦେଖି ସେ ଆସିନଥିବ ଟ୍ୟାଗ ହେଇନଥିବ
In fact, the person was appointed. His name was recommended by the Panchayat to the BDO. BDO accord approval, and the same was sent to the sub-collector, chairman of the section committee, who is to accord the same. And while the petitioner,
Mr. Joshi, Justice Narsing's order was to take a decision with such and such.
Yes, my opinion number 3.
If they have taken a decision, either way, rightly, wrongly, whatever, then the contempt is no longer matter.
No,
it has to be dropped.
That is what I want to take instruction.
What instruction will you take?
In fact, the recruitment process started way back in 2013. In between, number of writ petitions been filed, and I was appointed since 2010. My name was recommended. It was not taken into consideration.
So you will have to, if that decision has been taken against you, you have to file you have to challenge it in another writ application. How will the contempt?
Recruitment of the year 2013. I'm confused. It's 2010. In 2013,
I don't understand, sir. Let us see the order. The alleged inaction of the sub-collector cum chairman regarding approval of re-engagement Jogan Sahib in terms of resolution grievance of the petitioner. Taking note of the limited grievance, it is directed that the sub-collector cum chairman selection committee shall take a decision in the matter within a period of 2 weeks.
Yes, sir.
So he has taken a decision.
Hello?
He has taken a decision. It may not be to your liking. If it is not to your liking, you challenge it.
They have not been communicated. By
he said it has been communicated by ordered on 5/7/2022 it was communicated.
Let's keep it Friday. Just this.
I will keep it Friday. As directed, compliance affidavit has been filed by the proposed contemner. The same be kept on record. Learned counsel for the petitioner shall obtain instructions from his client in this regard. Let this matter on 12th. Sarla man sarla. How to write it? Upon if the order is not to your liking, you have to file
Yes,
an
yes,
application.
yes, that-
Who's stopping it?
Yes, that.
Yes.
Obliged.
Item 31,
Correction will be made accordingly.
item number 32,
Same order.
item number 33,
Same order.
item number 34.
34. First time it has come. Kahin ki second time? Kौन medical? This is extension. Extension of interim bail. Why second time? This has come for the first time. Are you not aware of the facts, sir? This is your matter. You are granted interim bail on 28/2/2024 for a period of 6 weeks. Yes, why do you want extension?
କାନଟା କଣ କଟିକି ଖରାପ ଅଛି ଡକୁମେଣ୍ଟ ଦେଇଛି ନା
Therefore, extension of interim bail is made on the ground of illness of the petitioner. Some medical documents have been enclosed to the IA. We seen that the petitioner is suffering from some ailment relating to the ear and hearing loss. Considering the submissions and the ground on which the prayer for extension of interim bail is made, I am inclined to allow the same. The interim bail granted by the order dated so and so is extended by a period of 4 weeks.
Item 35,
Permitted to withdraw.
item number 36,
May extension of time, SC/ST.
First time,
Second,
1 week.
SC/ST.
ECST कौन है?
Notice,
All at 2 weeks. 2 weeks. Weekly आरंभ करें? मीटिंग जाएंगे She told him she locked the door of Anganwadi, went to her house, and her colleague informed her that theft by mobile phone, that a gas cylinder.
ଗ୍ୟାସ ସିଲିଣ୍ଡର ମାଣ୍ଡିଆ ଚୁନା ଶିଶୁ ଖାଦ୍ୟ
ଶିଶୁ ଖାଦ୍ୟ ଖାଇଗଲେ
ଏ ଅଙ୍ଗନବାଡିରେ କଣ ସବୁ ବିକି ଦେଇଥିବେ ଅନନେସେରୀ ଗରିବ ଲୋକମାନଙ୍କୁ ହଇରାଣ କରୁଛନ୍ତି।
ଏକଦମ ନିହାତି ନିରୀହ ଲୋକ ଆପଣ ମାନେ ଏତେ ନିରୀହ ଲୋକ ଆପଣ ଯେ କାହିଁକି କହିଲେ
ଗୋଟେ ଜିନିଷ ପିଟିସନ ନମ୍ବର 1 ର 16ଟା ଆଣ୍ଟିସିଡେଣ୍ଟ ଆଉ 2 ର 39ଟା 39
18ଟା କେସ୍ ଲଗେଇଛନ୍ତି 2022 ର ଗୋଟେ
ସିମିଲାର ନେଚର ସବୁ
କେବେଠୁ କଷ୍ଟଡିରେ ଅଛନ୍ତି?
Custody, I was arrested on 22/7/23. In this case, remanded on 2/9/23.
ହେଲା 2923 will ଧରିବା technically charge sheet has been submitted.
Yes, yes.
All right. Impose stringent conditions.
Man.
It is the only petitioner.
The only petitioner. Yes.
The petitioners are in custody since
2/9/2023,
being remanded in connection with this case. Being remanded in connection with such case. Yeah. It is alleged that the petitioners committed theft of several food articles from the Anganwadi center along with a gas cylinder. Gas cylinder which you could name.
Yes.
Randhi khai.
It is submitted that the petitioners have been falsely implicated in the case. And in any case, charge sheet has already been submitted. Stop. Taking note of the assumptions as above and the period of detention and custody, I am inclined to allow the preferable let the petitioners be released. Condition Korandu, both of them shall appear before the IIC of Talsara police station. Na konera?
Sundargarh Sadar.
Talsara police station on every Sunday at 10 a.m. for a period of 6 months.
Other cases are also same.
Each date appearance in the court without representation. What about 96?
96, they are remanded in this case on 9/8.
Remanded on 9/8. Shitikejan petitioner.
Say there be same.
This
one ଖାଲି ଚୋରି ହେଇଛି
ଗୋଟେ ଫ୍ୟାନ ଆଉ
100ଟା ଅଣ୍ଡା 100 କେଜି ରାଇସ୍ 210ଟା ଅଣ୍ଡା।
ये फूड आर्टिकल्स कर दो फूड आर्टिकल्स कर दो तो वाला
এটা সুন্দরগড় সদর পিএস র কেস
देखिए कब
item 97 item 98
This case, the petitioner is the husband and is in custody since 14/4/2023 है। The allegation that after 15 years, 3 times this court granted opportunity to the State Council to produce case diary.
Yes,
per copy of the statement and final form of the email.
one more. This is a case of murder.
No, this is a case of suicide.
Hello. Allegation of 302, 304B is there.
30B omitted in the final form.
306 has been
not added.
Then 302 is only there.
Only there.
Also, all right.
One more
Three times.
Last chance will be granted.
Yes.
Up-to-date case diaries has not been produced despite repeated orders. Last chance is granted to the State Council to produce the case diary, failing which the matter shall be disposed of on the basis of available materials on record. Place this matter in the week commencing 22nd April. Yes.
Item 99.
April. In this case, my lord, section 6 OPID Act.
Mr. Bhuya is not there. You were directed to take some instructions.
Deposit, my lord, his custody since 2/11/23. All his bank accounts have been seized. His father-in-law were supposed to give financial support. Now he is hospitalized in Acharya Haryar because he has been detected cancer. Today, chemo is being started. The petitioner as well as his wife, they have been declared as defaulter. Their civil is bad. They are not in a position to get a loan of even 500. But their daughter, the wife, went to a bank with gold ornaments to get 50,000 gold loan. That she could not get it. So property security, your lordship allow Oh, his
security will be there, but since considering the huge amount,
that 22 lakhs, my friend misled this report. That 22 lakhs since 2021 to 1723, per month he has got his remuneration and
anyway, let it be passed over because he is not there. Let it be passed over. Maybe he'll come after recess. We'll pass it over because there was a specific direction to Mr. Bhuya to address the court as regards the personal involvement. Because last time also you made this submission.
Here what has happened? They have filed the charge sheet on 27/2. Investigation is completed.
Right, let him appear. Let him appear. We'll hear the pass over.
Item 100.
Item 100. Now immediately I'll begin the pass over matters.
100, my lord. Day before yesterday, Mr. Das made a mention before your lordship to take up the matter on Friday.
On Friday, yes. Pass over. Pass over. 100 pass over ମାନେ Friday ଆସିବ. Friday ଆଉ ରହିବନି matter କିଛି ଦେଖିବା.
ଆଇଟମ 97 ଟା ଟିକେ ପାସ୍ ଓଭର ହଉ ଭିସିରେ ଅଛି
ପାସ୍ ଓଭର ହେଇଛି ପାସ୍ ଓଭର ହେଇଛି.
ଆଜ୍ଞା
Yes, now we'll begin from the beginning. List is complete. List is done.
Yes.
Yes. Now we'll begin with the pass over matters. Please wait. Let Mr. Bhuya come.
There are, may I pray after lunch, first item, can it be taken?
I am ready to take it up, but provided Mr. Bhuya is there. So you inform Mr. Bhuya if he can.
But the main accused has been released on bail.
That's all right. That's all right. But let him come. Let him come. Please inform him if you can. Yes, item.
List pass over item number 2.
2. Again pass over.
So item number 8.
Here the coach demo.
Here,
Item 8. Yes.
more than the only ground is my lords, more than 7.5 years he is behind bars. 8.5 years he is in custody.
This is that CBI matter.
Yes, my lords.
But where is Mr. Naik? Here last time he had taken time. You have filed any interim application, or I was thinking of granting you interim bail?
Your lordships may for some particular period of time because well, it's for 8.5 years man is behind bars and the maximum sentence to be imposed is 7 years.
That has not found favor with the either with me or with the Supreme Court also.
No, my lords, I'm not on that. There, your lordships, what we had submitted is that he has remained more than
maximum period of.
Your lordship said that though it is triable by magistrate first class, at best it can go to the CGM who can extend the imprisonment for 7 years. So, but there is no enabling clause in
436.
Yes, so your lordship
436A.
Your lordships dismissed my application saying that there is no enabling clause, so we will not do that. But if your lordship goes to the root of the matter, if imprisonment, I mean, if he is incarcerated also, if he is convicted, well, then at best it will be for 7 years.
Yes. No,
so now 8.5 years.
What I'll do is I'll ask your associate.
Yes,
to please inform Mr. Naik. Because last time I had told him categorically that if you do not complete the trial,
yes,
the petitioner cannot remain indefinitely. So you consider whether interim bail can be granted. I asked him to take instructions with regard to the interim bail.
Yes,
if I remember correctly.
Yes,
but since this is a passover matter, probably he is unable to.
He'll inform. By chance I'm not present, Malus. The only submission I have is 8.5 years of.
No, it's better that you remain here in this matter.
Malus.
Whenever it is convenient to you, I am willing to take it up.
No, he was in fact telling him, Mr. Naik, that 215 or something, Malus.
No. That such times cannot be granted. No, I'm sorry.
He was saying, I don't have any. So you'll have to fix up another date.
Next time when it is called out, if you can, if he is available already. If he is not available, then I cannot accommodate like this.
No, that he was saying 215. I have no problem. I'll come anytime your lordship calls.
So I'm passing it over again. I'm passing it over.
Yes,
as and when you mention, I'll pick it up.
I'll see when he is there.
Yes.
I'll mention it.
Yes.
No, 8 list to pass over. 11 pass over.
Yes.
No, it will come up on another date or today?
Today itself. Because there are one more, the list is done, but still I have Friday for all the passover matters.
Say not today then.
From now onwards, I have started calling the passover matters. Today, I think.
Today then file.
So item number 24. 24. No.
20B2C of NDP circular, page 10 of the affair. The basing upon the statement of the co-accused, present petition's implication. The mailor towards bottom mailor, page 10 mailor. On being asked, the helper of the vehicle disclosed his identity as Kumarana, son of So, PSND, and further stated the rider of the vehicle who fled away from the spot is his identity Bonizarana. Bonizarana, present petitioner. And found 9 number survey which emitting acute smell. From the smell, I would come to know that Gonza of my farm service experience. On the interrogation, the accused Kumarana helper stated that as per direction of Angad Rana and Babula Rana, son of Sura, both are of village, they were transporting the Gonza to Bodbil town of Keonjhar district. Babula Rana has been granted bail, page 13, annexure 2. Against Babula Rana, procurement has been done against the present petitioner, co-accused statement, and he has fled away from the spot. This is the difference.
Yes, this is the difference, my lord. That person has been granted bail. That person interrogated that Kumar Rana stated as per direction of the person, Babula Rana, they were transporting. And this present petitioner was the driver who fled away from the spot, my lord. But no seizure, co-accused statement.
So this is anticipatory bail?
My lord.
Yes, my lord. Quantity is used, 405 page.
But if there is no evidence, so
no, my lord.
The petitioner is apprehending arrest in connection with such and such case. The prosecution case is that contraband ganja weighing 405 kgs was being transported in a vehicle when it was apprehended by police. The helper was nabbed while the driver fled away. On interrogation, the helper gave out the name of the petitioner as being the person who fled away. Stop. There is no other admissible evidence. It has same order kar diya. Ja achi. Yes.
So right now 34.
Item 34, your receipt through NOC have stand here. Your receipt will let it come on Friday or next week.
NOC?
NOC have stand here. That previous council.
Oh, you are appearing now?
Yes.
All right. Password? Password will Friday or come?
Next week, yes.
Will this matter next week as
documents call for
all right.
Again. Monday, Tuesdays.
No, it will come in the weekly list.
Weekly list. Top of the list.
No, why top of the list? Top of the con. Weekly list is
Friday.
No. Friday. Password?
Yes.
45 days on Fridays and
Friday.
so item number 42. So item number 48. So item number 50.
50 it was specifically adjourned to
Friday.
So item number 56. So item number 57.
May I please the case is under section 302 and 34 of the IPH matter. In this case, name of the deceased matter Lachu Antar and present petition name Sanyasi Rao alias Sonu Mari matter. And the brief fact of the case matter that on 7/7/2023 evening at about 5 p.m. the informant elder brother Lachu Antar, the deceased, went to the house of Kandra Hantala for taking alcohol. At that time, Sonu Mari of village Kandulapada present there. All 3% taking alcohol, and after few minutes, there is an
assault is by Kandra Hanta.
The present petition given only slab manner, and Kandra Hanta
and leading to discovery that axe was also seized from the Kandra hunter. Present petition role is minor limited. He only slapped that deceased.
Well, since when are you in custody?
9th July 2023.
The petitioner is in custody since 9/7/2023 in connection with such and such case. It is alleged that the petitioner, one Kandra Hantara and one Lakshu Hantara were taking alcohol in the house of Kandra Hantara, the petitioner. There was suddenly a quarrel between them by exchange of hot words. Kandra and the Kandra Hantara petitioner. So petitioner Kandra Hantara petitioner petitioner part the petitioner and said Kandra Hantara assaulted Lakshu by means of fist blows and slaps. Suddenly, Kandra brought an axe from his house and assaulted Lakshu on his neck, causing his death at the spot. Insofar as the petitioner is concerned, the only allegation against him is that he had slapped Lakshu, other deceased. The main allegation, the main allegation of assault by axe is against co-accused Kandra Hantara. Furthermore, the incident appears to have arisen out of a sudden quarrel without any premeditation, for which, prima facie, the offence under section 302 IPC is difficult to be made out. Taking into consideration all the above facts, as also the period of detention and custody, I am inclined to allow the prayer for bail. Let the petitioner be released.
Item number 58. Filed an IA for interim bail on the ground of that the mother age is 68 years old, suffering from different old age ailments. Local persons from custodians. Bail.
Have you checked this document, Mr. Divedi? Have you checked up this document? Are you sure that it is a genuine document?
Yes, madam.
Have you checked up?
It's a genuine document.
I will direct an inquiry. Once in Kondamar, in case of Kondamar, this very DHH, there was a adverse order was passed. And this has been filed in 2023, this interim bill.
Okay.
This document also relates to September 2023.
Same time.
I leave it to you. Don't take the risk.
No, I will not risk.
Don't take the risk.
Yes.
Because this appears to be a fraudulent document. And we prepared for the purpose of this case. If it is a genuine, I'll direct the State Council to take instruction. Yes.
Not press like
No. Check have you checked it? If you have checked it, if you are satisfied, the court will accept your version.
Lower court advocate sent.
So that is the problem.
Yes.
That is the problem. That is the problem. You have no means of knowing other than believing the. So let us find out. If it is found to be genuine, well and good, nothing. It's not as if all documents emanating from the DHS Kondamar are false. I am not saying that, but there have been some instances.
So I will in the meantime take this.
All right. Let's this matter next week.
Yes.
As the Land Counsel for the petitioner wants to take instructions from his client and client. That's all.
So item number 61.
I think my friend has come.
All right. We'll take it. Item?
Item 61.
61? No one is there. Yes.
Item 62. May plus. The petitioners custody since 1/8/2023 20B2C along with other offences of the Indian Penal Code. The seizure was not made from the conscious possession of any of the accused persons, and the seizure was made from a community hall. And subsequently allegations made that some of the villagers, my lord, tried to
assault
the police, and some of the accused persons.
What is the allegation against them? My lord, what is the material against them?
Some ladies have been
My lord, from the local inquiry, it is ascertained that all the villagers, and from the local inquiry, it is ascertained that they are fled away from the spot. But it has been stacked in a community hall, not seized from their position. But while scuffle, some police person has injured, my lord, 2 persons.
No, they are not arrested from the spot. Later on, they were arrested, and the local inquiry ascertained that some persons, along with all the villagers, protested the action of the police. So the seizure is made. It was from the community hall. No one is present at the spot.
From the statement recorded from the police persons, it is like this. From the local inquiry, it is ascertained that
local inquiry
accused person, namely such and such,
petitioners having
No evidence.
not
The
petitioners.
petitioner.
in the
The petitioners are in custody.
Some of them, police person has injury.
1/8/2023.
That is simple matter.
1/8/2023.
1/8/2023 in connection with such and such case. The prosecution case is that huge quantity of contraband ganja weighing kete 1148 kgs was stored in the community hall of Balipodara village. Stop. Same was discovered during a raid conducted by police. On seeing the police, several villagers abused and assaulted them by means of deadly weapons, causing injury to some of the police personnel. The petitioners were arrested subsequently and during investigation. It is stated that their involvement came to light from local inquiry conducted by the IO. The perusal of the case diary reveals that there is no material or evidence to show that the petitioners were involved in storage of the contraband inside the community hall. Stop. As regards the assault on police, also, there is no clear-cut evidence showing their involvement. The IO has stated somewhat vaguely about the involvement of the petitioners, purportedly on the basis of some local inquiry, without naming the source from which he obtained such information. In the absence of an nexus between the petitioners and the alleged occurrence, their detention cannot be justified. Therefore, notwithstanding the fact that huge quantity of contraband was seized, yet in the absence of any evidence to link the petitioners with either the storage of the contraband ganja or in the assault on the police personnel, I am inclined to allow the preference. Let the petitioners be released. Condition code. They shall appear before the IIC of Kothana, Baliguda Police Station on every Sunday at 10 a.m. for a period of 6 months. Each day appearance in the court without seeking representation. Yes.
Unconnected.
That's Sangarochi. Same order.
Item 61. I take that one, madam.
21.
22 years.
As prayed for, list this matter in the week commencing 22nd April.
So item number 66.
Madam, kindly take up the matter after 1 week.
After 1 week. List one moved.
So item number 67.
Pass over.
66, my lord, put up one. Right.
So item number 68. May I please, your lordship? My lord, here, my lord, allegation of the offence under section 307, 325 of the IPC reduced to 25, 27 of the Arms Act. Here, my lord, that I have 8 number of criminal antecedent, my lord. I have already filed, the mother of the present petitioner have already filed the affidavit, my lord, on that regards. Here, my lord, the present petitioner was arrested on 6/8/2023. And thereafter, my lord, charge sheet has already been filed, and the person who injured received the gunshot injury. He has already discharged from the hospital. But fact remain, my lord, as per the statement of the injured in this case, my lord, this present petitioner will not have.
Let us see the
Statement, but it's grievous, my lord.
Grievous, but statement of
The
the
remark is grievous and
no, I want the statement of the injured.
injured. ମୁଁ ଆଜ୍ଞା ତାକୁ ମେଡିକାଲ ନେଇଥିଲି। ମୁଁ ପଢୁଛି ଆଜ୍ଞା statement of the injured, my lord. Name is, my lord, that Shakti Charana Mohanty. Last portions, ରାଜା ମତେ ଜୀବନରୁ ମାରିଦବା ଉଦ୍ଦେଶ୍ୟରେ ରାଜା ଆଲିଏସ୍ ନିଶିକାନ୍ତ ମତେ ଗୁଳି କଲା। ନିଶିକାନ୍ତ is not the present petitioner. ଉକ୍ତ ଗୁଳି ପେଟରେ ବାଜି ମୁଁ ସେଠାରେ ରକ୍ତାକ୍ତ ହୋଇ ସେଇ କଳଘର ପିଣ୍ଡାରେ ପଡିଗଲି। ଗୁଳିର ଶବ୍ଦ ଶୁଣି ଗାଁର କିଛି ଲୋକ ଆସିଯିବାରୁ ରାଜା ସେନାପତି present petitioner before your lordship ଆଣିଥିବା ବୁଲେଟ ମୋଟରସାଇକେଲରେ ମତେ ଆଣି ମାର୍ଶାଘାଇ ମେଡିକାଲରେ ଛାଡି ଲୁଚି ପଳାଇଗଲା। ମୋର ଅବସ୍ଥା ଗୁରୁତର ହେବାରୁ ଡାକ୍ତର ବାବୁ ମତେ ସେଠାରୁ କଟକ ରେଫର କଲେ। This is the statement of the injured, and charge sheet has already been filed. He has already discharged from the medical, and I'm in custody, my lord, since 6/8/2023. But admitted, my lord.
the injured statement, my lord.
Pass over. Is it a certified copy?
No, ନାଇଁ ଏଟା ହଉଛି ଆଜ୍ଞା ଚାର୍ଜ ସିଟ୍ ର କପି ଆଜ୍ଞା।
ଦେଖନ୍ତୁ
ଆଜ୍ଞା।
It must be there in the case diary.
Case diary is there, one. Shakti Charan Mohanty.
You find out. You find it. I'm passing it over. Mr. Sahu, I'm passing it over. You let him find out.
ଅଛି ଶକ୍ତି
Pass over. Pass over.
ଚରଣ ମହାନ୍ତି।
See, ଦେଖନ୍ତୁ. Let him find out. Yes. Why should you wait? Yes. Next.
So right now 71. Injured statement
ନାହିଁ ଆଜ୍ଞା।
ଆମେ ଦେଖିଦିଅନ୍ତୁ ଲଞ୍ଚ ପରେ ନେଇଯିବା।
Yes, ma'am.
Mr. Sahu will take it up after recess.
ଆଜ୍ଞା।
Yes, ma'am.
Item 71. No, nobody. Yes.
Item number 76.
May I please, your lordship?
Yes.
Well, at offense under section 395, 450 and 397.
Yes.
Allegation.
397.
Yes, my lord. Allegations.
Would you care to please pass over the FIR?
Sorry, my lord, FIR not filed, my lord.
So,
May I
give me
pray
FIR.
any other day will file FIR, my lord.
Let this matter next week as paid for, and counsel the petitioner shall file the copy of the FIR.
Obliged.
Chalo.
Item number 82.
Chalo.
Item number 84.
Chalo.
Item number 90. Item number 92.
Petition reminded in this case, my lord, custody since 27/9/2023. And the other co-accused person, one Sauri Naka, has been acquitted in the meantime. Allegation is that.
Where is the FIR?
FIR, this is the FIR. ସେଥିପାଇଁ ଦେଲେନି ଯେ ନହେଲେ ଡିଫେକ୍ଟ ଆଉ ନମ୍ବର ହବନି।
ଟାଇପ କରି ଦଉନାହାନ୍ତି। ନ ପଢିଲେ କେମିତି
ଖଲାସି co-accused acquitted in the meantime and
maybe what is the matter? I don't understand.
While the informant is the supervisor supervisor of a construction company.
Yes.
At that time, the petitioner, along with other co-accused who has been acquitted in the meantime, they went there and asked for Dadavati. That is the allegation.
No, this Vibhujina, he has fired from his gun. Luckily, he has escaped. And other members who has come, they have assaulted. He has received some simple injury, my lord. But he has fired 2 rounds and
nobody has received any
gunshot injury.
All right.
But
the
15 CA is there against.
How many?
15.
I will direct him to appear.
No.
The petitioner is in custody since Yes.
27/9/23.
27/9 to 2023 in connection with such and such case. It is alleged that the petitioner fired from a gun at whom?
This Srinivas Jena
He is the informant.
is the informant, my lord, injured.
Yes.
Fired at the informant. But luckily, the bullet did not strike him. Other persons assaulted him, causing some injuries. So, insofar as the petitioner is concerned, there is no other allegation. The co-accused, Souri Nahak, has in the meantime been acquitted of the charges by the trial court. Copy of the judgment passed by the trial court in respect of Souri Nahak has been enclosed to the bail application. The petitioner stands on the same footing. Under such circumstances, I am inclined to allow the prayer for bail. Let the petitioner be released. Condition: he shall appear before the IAC of Kothana,
Kollikot. Yes.
Kollikot Police Station on every Sunday at 10 a.m. for a period of 3 months. There will be each day appearance in the court without representation.
Obliged.
Item number 97.
97 से कॉलेज पास आउट करेगा नेक्स्ट वीक को ना पास आउट करेगा
Item number 99.
Yes, Mr. Patra. Last time you were directed to look at Mr. Bhuya, Learned Counsel of the State in OPID matter shall address the court as regards the personal involvement of the petitioner, if any, in the alleged occurrence and the role played by the petitioner at the time of occurrence, in view of the fact that he was not a director of the company at that time.
Miller.
So, what is your instruction?
Miller.
You are Pankaj Kumar Poridan. You, what is your name? Pankaj Kumar Poridan.
Pankaj Kumar. I have also given the document that is at page 38. You lordship kindly see that is
that you have seen on that day.
Ministry Corporate Affairs has granted.
So what is your instruction?
Last year, my lord directed what is his role prior to became the director of the company, Miller.
What is the total financial involvement? 22 lakhs.
7 crore, 76 lakh, Miller.
You respond to this.
You lordship kindly see their allegation is that total sum of rupees 22 lakhs 13,731 is credited to his ICICI Bank account. Whatever the amount to the depositors have deposited, my friend also will admit that all the amounts is deposited in the account of the company. So only 22 lakhs that has been paid towards his remuneration from 18/10/21 to 1/7/23. Towards remuneration, salary, because he was an employee of that company. So whatever the deposit, 7 crores or 8 crores, I don't know, all the amounts have been deposited in the company's account. And the man accused, my lord, he has been released in bail because the OPID failed to constitute the medical board.
That is on the health ground, Miller.
Health ground, but
Yes.
man accused.
Yes, on the health ground.
This is on the interim bail.
Interim bail. So, so far as the present petitioner is concerned, my lord, he is since custody since 2/11/23. Against him, charge sheet is filed. Only allegation that 22 lakhs somewhat has been credited to his account, transferred from the company's account on different dates. That is from 18/10/21 to 1/7/23.
Yes, you are saying something what he has done prior to becoming the director?
Yes, this is my affidavit, Miller. Prior to what is his role prior to becoming the director of the company, Miller. Yes, Miller. Kind of a glass. Initially, I was appointed as an employee, annexure A, Miller, 18 lakh per annum, Miller. Subsequently, what happened, Miller? He along with others, Miller,
arrange meeting in directly involved in the help of the affairs of the company, arrange meeting and induce other person to invest in the company so that they will get 8% per month. When person deposited and demand that 8%, they have told him, Lord, you collect another person, thereafter we will pay the percentage. Kind of a glance. Annexed A series and B series, my lord. These are the meetings, my lord. Present petitioner with others, my lord. So many persons, my lord. In hotel, my lord.
All these things are subject to trial.
Yes,
This is bail application.
No, I would like to know, so what is the amount that has been credited to his account is 22 lakhs.
22 lakhs.
That 22 lakhs, has it been secured? No.
Property security, your lordship.
No, what happened to that amount? 22 lakhs. What happened to that 22 lakhs?
But that is regarding towards his salary. He was an employee. Monthly salary remuneration. He has spent all the bank accounts they have seized. Your lordship kindly see.
And this way, then
all the bank accounts have been seized. Charge sheet is filed. Allegation is that 22 lakhs somewhat. But whatever my lordship submitting, it is subject to trial. Your lordship kindly see all the bank accounts.
No, that is subject to trial. No. That is true, Mr. Das. That is true. But the thing is that you know the.
Your lordship kindly
you know the judgment of the Supreme Court.
Condition.
Sir, please allow me to complete. The Supreme Court is very clear that in economic offences, the court has to take a very strict view.
No, that is correct, my lord. Your lordship kindly see para 48. I am giving the Supreme Court. The term and condition the Honorable Apex Court has given. That term and condition, your lordship kindly impose and para 48. Money is secured, my lord. They have freed the company's account also.
But in the account, there is zero balance.
No, company's account.
Miller?
Company's account.
No balance, Miller.
These are all monthly accounts.
What about the company's account? Where is it? 5 crores or some crores, 7 crores was deposited according to you?
That is the account at the Miller, Noida, Miller.
Yes, what has happened to that? What has happened to that? It must have been seized. The account must have been frozen.
Miller.
Please find out.
Yes.
No, I will definitely. So we
also can impose the cost. He is not running away.
No, why will he not pay any money? Let him pay some money.
No,
pay some money.
But the fact remains, his custody since 2011. Now all his accounts have been freezed.
This court will not believe that he only had this much of property. He must be having bank accounts elsewhere also.
No, definitely. You also kindly see this is a list. All the bank accounts.
No, that's all right. But how do we know that he does not know?
Well, he has a building at Baleshwar. You will also kindly see a property security. Building whose value will be around 35 lakhs to 30 lakhs.
Yes, what do you say?
Then my assumption, my lord, there also this company had differed in the 12 state, not only Orissa.
That is true, Mr. Batra. I am saying what about the let us make a segregation. Because he was a director as per the ROC certificate from a particular date. Prior to that, he was a employee, as you have yourself enclosed the documents.
Yes,
that he was appointed as a general manager.
Yes.
So company or किसी company general manager, regional manager, they are all bunch of thieves. It's complete. Their aim and intention is to cheat people. So that the court understands. But speaking of the documents, then we find that ROC has, as per the ROC document, he was a director from a particular date. Prior to that, the occurrence has taken place prior to that. Now, the company, some deposits have been made into the company's account. Some crores.
7 crores, 76 lakhs.
It is deposited. So he being just an employee at that point of time, obviously whatever amount has been transmitted, it can be validly argued that it was towards his salary.
It is
so
there.
I would like to know what happened to that Amount which was deposited in the company's account. What happened? Was that amount secure?
That is withdrawn by the company, my lord.
That has been withdrawn by the company.
Yes, my lord.
So,
Even if 22 lakh are deposited in the petitioner account, that has also been withdrawn, my lord.
No, monthly salary, my lord.
Monthly salary 22 lakh income.
You will also can see in today's affidavit in para 7 also same thing they have said.
No, but monthly, your monthly salary was how much?
Annual package was 18 lakhs. It was for the period from 18/10/21 to 1/7/23.
All right. So how will it be 22 lakhs at one go?
No, not in one go. Not in one go. Monthly. It is credited on several dates monthly.
So total amount comes to 22 lakhs.
Total amount is 22 lakhs.
All right. I'll go through and pass orders. Give these documents.
Miller. I'll pass on the charge sheet.
Any condition your lordship, I have given the Supreme Court. He will run away. He will not run away.
May that you see as your well interim well in health ground that is not connected to this, my lord.
Well. And your lordship grant any term and condition, you will appear before the IA once in a
You have to deposit money.
Yes.
Without money, deposit no money.
My lord, your lordship kindly grant property security.
Along with property security. Along with property security.
Of cash, my lord, it will be difficult. Your lordship may allow to be released on bail after 1 month. You will arrange some money and
I will grant interim bail then.
Yes.
I will see your bona fides. I will grant you interim bail. Within 1 month, you deposit some amount. Whatever amount I will find property. Yes. In all cases, Mr. Das, it is not as if this is the only case. In all such cases, you can take you can ask your friend from the other side. In all such cases, property security, property security.
I will give in the Baleshwar town, that property is there. House 2 or 3 story building, whose value will be.
Give the details. Give the details. Give the details. Give the details. But along with that, some money has to be. I will grant you interim bail for a month. Then you show your bona fides. Then I will make it absolute.
His wife was not in a position to get the 50,000 rupees loan because now they have been declared their civil is bad.
Mr. Das, with your vast experience, I'm sure you will not believe your client. We were making a submission, that's all right. With your vast experience, will you believe it? And you expect the court to believe it? I'm willing to grant you bail. I'm willing to grant you bail, but on condition.
The fact is, I never conducted any criminal case.
So what? I also never conducted any criminal case.
Because one petitioner is one of relation of my lawyer friend. That is why.
No, I said what?
So your lordship allow him to release on bail. Property security, initially you will give property security. After release, from within after 1 month from the date of release, you will also grant some cash security.
Yes, that's fair enough. Fair enough. I will keep it 22 lakhs. That 22 lakhs, that will keep in mind to find out what money he can deposit just to show his bona fides. That's clear. All right. I'll pass on that.
He has received towards his salary. So 22 lakhs. Since
not salary credit commission,
maybe towards his commission, doesn't matter. But Mr. Patra, you please realize also one thing. Insofar as the other deposit is concerned, which is said to have been made to the company's account, that 7 crores or something, there's no nexus. That nexus is missing.
And here's another case below in Visakhapatnam also. That is also
habitual. I'll pass orders, Mr. Das. And so far as your lack of criminal practices is the same as with the court also.
Pass on the charge sheet copy.
Please.
Yes.
Give the entire case diary.
Yes.
You do one thing. You make it ready and then give it.
Yes.
Not sit flag mark so that it will be easier to find out.
ସେଗୁଡାକ ସବୁ ଯାହା କହୁଛନ୍ତି ଟ୍ରାଏଲରେ ଆସିବ ତେଣୁ the bail is concerned.
No, order has to be passed, so I have to go through the case. It's not right.
Bail is a rule.
No, but Supreme Court thinks otherwise in economic offences. Jagannath Reddy, why Jagannath Reddy versus an many other cases.
Then recently Supreme Court in a case 2022, that is Satinder Kumar until there Supreme Court has taken the liberal.
Previous figures in Jagannath Reddy, but still they are categorized.
There they have said that bail is a rule, jail is the exception.
But there also economic offences have been separately categorized.
Yes, yes, yes.
But one thing, if suppose you will be in jail, what will be the benefit to the EOW? Whether they will get